authorized symbol of excellence in sports entertainment.
The information made available via this podcast is for informational purposes only and not for the purpose of providing legal advice. You should contact your attorney to obtain advice with respect to any particular issue or problem. Use of and access to this podcast or any of the email links contained within its website do not create an attorney-client relationship between Michael Dawkins, Shoemaker, Loop, and Kendrick, and the user or listener. The opinions expressed at or through this podcast are the opinions of the individual author and may not reflect the opinions of the Shoemaker firm or any other attorney.
Hey everybody, welcome to another episode of Wrestling with the Law. I think we're on episode 9. This is Mike Dawkins, also known as the Gimmick Attorney, a partner with the law firm of Shoemaker, Loop, and Kendrick, with offices in the cities of Detroit, Toledo, Columbus, Ohio, Tampa, Florida, Sarasota, Charleston, and Charlotte, North Carolina. You can visit our website anytime you want at shoemaker.com. That's SHUMAKER. So today's topic, we're going to talk a little bit about dirt sheets, but probably not the dirt sheets you're expecting, not Meltzer or Alvarez or any of those guys. Really, I guess it's not dirt sheets. It'd be the magazines, the Aftermags, but not an Aftermag. We're going to talk about the case of Titan Sports Inc. versus Comics World Corp. This is a case that happened in July of 1988. So Comics World Corp is the name of the company, of course, but not the name of the magazine. The name of the magazine, if you've ever heard of it or if you're familiar with some of those 1980s magazine, is Wrestling All-Stars Poster Magazine. And we've got a couple of issues and covers that will flash up here due to the beauty of editing and the editing assistants that help with this. But Wrestling All-Stars Poster Magazine is what we're talking about. And Titan and Vince McMahon and the team took on these magazines because they felt that the magazines were using the rights that Titan owned, that WWF owned, to publish images and things of wrestlers that they weren't allowed to do, that they were violating the rights of publicity that Titan had on behalf of the wrestlers. And really, what they were complaining about was not the magazine and not the articles in the magazine, but the magazines had posters in the middle, centerfolds, if you will. And for all you young kids out there who just read anything on Kindles and on computers, magazines, these paper things we used to buy in the newsstands in grocery stores or bookstores and things like that. Certainly when I was growing up, that's what I did. That's what I read. I'd get dragged to the grocery store with my mom or my dad, and they'd go one way towards the produce. I'd go the other way towards the magazine aisle, and I'd spend the half an hour, hour and a half, whatever it was, in that aisle, pulling out wrestling magazines and reading through them and looking through them. And if it was interesting enough, or if I couldn't get through it, I'd beg my parents, oh, please, please, please buy this for me. And so I've got to still have them all to this day. Never got rid of any of them. I've got a pile of them sitting in storage in the other room. And also, as you know, part of my birthdays every year, my dad would get me a subscription to the WWF magazine. So it was always something that I loved. I've still got this affection for magazines, and I have subscriptions to magazines that get sent to my house, and books. And my daughter has a love for reading, and she loves her books, and she refuses to read them digitally. She just absolutely wants to have a book and hold a book in her hands. And I get that. And so I have a love for these magazines even to this day. But anyway, WWF and Titan were saying, hey, the posters, the centerfolds, this is a problem. You're not allowed to do this. You are violating our rights of publicity, our right in our wrestlers, our performers, and you can't do this. So knock it off. And the comics folks, the Comics World Corp said, no, you're wrong. These photos are protected by the First Amendment. They're protected by the First Amendment because they depict noteworthy people of public interest. And if that's true, then these photos are not an improper use based on trade or for advertising purposes. So what happened in the procedure of the case is that the parties both filed motions for summary judgment. And so what's a motion for summary judgment? It's something that happens in the course of a trial before the end, before you get to all of the full discovery, and before you get to testimony and things like this. And you usually happen after discovery, at least some portion of discovery. But what it is a party makes a motion for summary judgment and says, hey, court, if you look at all the facts that we have in this case, and you look at them in the light most favorable to the other guys, to the non-moving guys, there's no way that you can find against me as a matter of law. So that's to say, you can look at everything in the light most favorable to Comics World, and we, Titan, should win. Well, Comics World did the same thing. They said, well, we think that's right. If you look at all the facts in the most favorable light for WWF, for Titan, we think you cannot possibly find against us, and we should win, and we're entitled to judgment as a matter of law. And so really there cannot be any material facts in question. And what does that mean? It means that any material fact that's in question means that a jury, a reasonable jury, could find that the fact is important for one party or the other. They could find either way, that it's a judgment call, and there's really no way for anybody to say, well, that fact that absolutely has to be interpreted for party A or party B. It's just a question that the jury is going to have to decide. And so both parties filed those motions for summary judgment, and that's how this case went away. We'll get to that in a minute. So in short, what Titan said is that the right of publicity is violated under New York law. What Comics said is, nope, it's sure not. We in these pictures and these magazines, Wrestling All-Stars poster magazine, is protected by the First Amendment. So as a refresher, let's talk about the right of publicity for a second. What is it? It's a right to prevent the unauthorized use of someone's name, likeness, or other recognizable aspect of their identity. It's not a federal law. It's always covered by state laws and state statutes. Some people call it a right of publicity. Others call it, they say it's a part of the right of privacy. And states differ on how that's protected. They differ on the nature and the extent of protection, whether it's going to be protected by statute or common law being things that have been decided by the court and the kind of the body of court decisions over time. Whether there's post-mortem rights after people died, that doesn't apply here. Whether the right of publicity is assignable. And, you kind of get this tension between the First Amendment and the right of publicity. Well, the state of New York covers this by statute. They have great right of publicity laws. They always have. Again, we've talked about this before. Other places that have great right of publicity is usually where there are a lot of famous people. So California has great right of publicity laws. New York, as we mentioned, Nashville, because of all the country music and things like that. Tennessee has great right of publicity laws. And believe it or not, my home state, Indiana, has pretty good right of publicity laws, because there have been quite a few famous people that have come from Indiana. James Dean, for one, and his estate and all that. He died young, and the state wanted to help his family and protect his right of publicity and all of that. So Indiana was able to conjure up and be kind of a leader in the forefront of right of publicity law. So New York has it. New York recognizes it, but that's what it is. We're looking at the unauthorized use of someone's name, likeness, or other distinguishable feature. Defenses about right of publicity, and so that you're not violating a right of publicity, include newsworthiness, right? That's what Comics World was trying to claim. It's an extension of the free press and free speech portion of the First Amendment. And then when other matters of public interest like parody and artistic works and creative works, doesn't really apply here. But it only applies to those that are of public interest and that are worth exploiting. So that's the only time that it could even apply this sort of defense. So what's the First Amendment say? Well, the First Amendment kind of covers three main areas and protectable things: the right of religion, right? Your freedom to practice religion and do whatever you want, freedom of speech of press, and the right of the people, freedom to peaceably assemble. So the First Amendment, I'll read it for you, as boring as it may sound. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people to peaceably assemble and to petition the government for redress of grievances. So, like I mentioned a second ago, what we're talking about here is the freedom of speech and freedom of press portion of the First Amendment, that we are allowed to say things, and we are allowed to put things in the press, and the laws that the government puts forth can't restrain that unlawfully, right? So the statutes of New York can't restrain that Comics World doing what they've done. So what are the facts of the case? Like I said, it's a magazine of posters that's at issue, not the pictures or any small pictures that are maybe included with the articles that are featuring each wrestler. And these pictures were stapled inside the center. They were centerfolds, and most of the time, if not all the time, you couldn't even see the full picture without removing the staples and removing the poster from the middle. The average size the court actually took the time to measure was 16 inches by 22 inches. So these are pretty decent size, right? A little more than a foot, almost a foot and a half by almost 2 feet. So that was a fact that the court found that to be important. Another fact was that the posters depict wrestlers, nothing outside of wrestlers. It's nothing but wrestling. It was not contested that the magazine did not have consent of Titan, of WWF, or any of the wrestlers. And there was another fact that WWF had a problem with, Titan had a problem with, is that the pictures and other pictures were being used by the magazine when soliciting for subscriptions and soliciting for the order of back issues. So if you're familiar with these kind of magazines like I am, I remember all the time, there were at least one, if not 2, 3 pages, sometimes in the middle, sometimes in the back, but it would show pictures of covers of previous issues, or it would show reproductions of the articles from previous issues saying, hey, you should get a subscription. It's cheaper to have it sent right to your house. You don't have to go to the store anymore. You don't have to pay newsstand prices. And, oh, you can get this back issue, this great Hulk Hogan issue from a few months ago. And so WWF was saying, hey, that's use in advertising, right? They're advertising for back issues. They're advertising for subscriptions. And so the court found, yeah, you know what? They were using names. They did reprint pictures and all of that of previous magazines, and they did use them in ads. So that's a fact that nobody really contests. WWF and Titan claimed, the pictures are posters due to their size and placement, rather than being with or associated with directly the article in the news. That is a violation of the law. And that was a fact that the court kind of had to determine and figure out, hey, is this important? Is this material? Is there a real question about this fact that the posters are indeed photos that are indeed separate from the articles in the news? And comics, to their point about the facts and about that fact in particular, said, well, the pictures correspond to an article about that wrestler. So there's no picture, there's no poster that features a wrestler that does not also have a corresponding news article in the magazine. And so therefore the posters are part and parcel with the magazine as a whole and deserve the full protection under the First Amendment. So that's kind of the facts that the court had to weave through and look at when they're considering the motions for summary judgment. So what's the rule of law? The rule of law says that the plaintiff, Titan, WWF, has to establish 3 things. First, that the defendant, Comics World, used the name, image, or likeness of whoever the people are, the wrestlers in this instance, within the state of New York. They also have to find that such use was for the purpose of advertising or trade. And then third, they had to have done those things, that is, used the name, image, and likeness in New York without consent for purposes of advertising or trade without first obtaining consent. The court's conclusion was, you know what, Comics World, you can do what you're doing. Play on, players. Your defense is protected. And here's why. As I mentioned before, the defendants, it's incontrovertible that they use the name, image, and or likeness of wrestlers. It's incontrovertible that they were in New York and they sold magazines in New York. It's also incontrovertible that they did not obtain consent. They never pretended that they had gotten consent from Titan or from anyone else. So really the question came down to, are these posters, are these centerfolds for purposes of advertising or trade? So in the court's finding, they said, yeah, nobody's arguing here. It's in New York. You used them and used without consent, but the use was not improper. We find, based on the facts, based on our review, that this was not an unlawful use. So they said these magazines, the Wrestling World All-Stars poster magazine, they were distributed like any other magazines, wrestling or not, but especially wrestling magazines, and they're intended for newsstand sale. They also found that, WWF wrestlers are newsworthy and they are subjects of, and I quote, substantial public interest. And wrestlers are public figures and public personalities, and accordingly, wrestlers are proper subjects for articles and photographs on on newsstand publications. So the courts didn't have any problem with that. And basically they were saying, hey, all wrestling magazines are okay. Whether the poster part is important or is a violation, we'll get to in a sec. Obviously, I already spoiler alert, already told you that they found it was okay. But they were saying in general, magazines, wrestling magazines, reproducing these photos and things like this of wrestlers. Now, mind you, you can't steal somebody else's photo. I can't steal, Jim Cornette's photos that he took and reproduce them without his permission. I can't steal photos from Getty Images. I can't steal photos from, the guy down the street's blog who was at the show and took photos. But my magazine can send somebody there to photograph, assuming they have permission or have a ticket. Maybe they're a front row person. They have the right to take pictures, and then I can use their pictures in my magazine. So I have the copyright in those photos. I'm not stealing someone else's photos. That would be a copyright violation. But the court was saying, yeah, you can do that. The wrestlers are newsworthy, and therefore you can create these magazines and you can publish these photos and use their name, image, and likeness. And that's okay. That's First Amendment protected. So the court then turned to the question about the ads, use of photos in ads and subscriptions and all of that. And they said, yeah, of course you can do that. That's all incidental to the allowed uses. So the photos were being used were just to show, hey, this is representative of what the magazine will look like. Kind of silly considering you're looking at it in the magazine. So you know what the magazine looks like, but for comparison purposes, maybe that if that's the first time you've seen one magazine, well, maybe it's not always this quality. Maybe it's always not this good or always not this bad. And so they said, the photos aren't primarily for advertising uses, that you are allowed to sample content of previous magazine, and you're allowed to sample that content in later solicitations for subscriptions or back issues. So why would the use of photos that are in there or covers of the previous magazines not be allowed to? That's just nonsense. Of course you can do that. And that the lists of names of wrestlers whose pictures have previously appeared. Oh boy, I'm an Andre the Giant fan, right? That's well established. I want any of these that featured Andre the Giant. So to have in the solicitation a listing of all the wrestlers' names and, issues 1, 5, and 7 featured Andre the Giant, well, that's information I might want to know. And that similarly is just kind of a fact that's incidental to and allowed in future solicitations, because you're allowed to do that. You're allowed to republish portions of your magazine. You're allowed to republish and reproduce the portions to try to entice people to buy the magazine and that sort of thing. That's all allowed. And the republications, the samples of the newsworthy content, courts are going to let it happen. So they let it happen. So what the court found was, Titan, WWF, you don't really have a claim that stands that the works were used for purposes of trade, because nothing at all on the record, none of the facts, nothing that was presented to the court suggested that the Comics World's use was anything other than a bona fide, factual, accurate photographic representation of WWF wrestlers who they established were noteworthy and newsworthy. And since the magazine was devoted entirely to wrestling, of course you have to have wrestlers in it. And of course, it's a bona fide intention to do this newsworthy story thing that includes photo. And the court found that it was very important and paramount even that Comics World in every issue had at least a full page article featuring the wrestler or any wrestler that was on one of the inserted posters. So it wasn't just take a picture of this guy and put it in there and not talk about him at all. That the court probably would have found differently. They said, no, they featured an article. This is just an extension of the article that the centerfolds correspond to and are part of the dissemination of a matter of public interest. So the fact that they're inserted into the middle and larger than the rest and all of that does not bar protection under the First Amendment, and frankly is irrelevant. That the court also found, in general, the magazine industry evolved in response to consumer requests and what consumers were doing. And, to the extent that people still buy magazines today, I suspect still do, they were pulling out portions of the magazine that they liked, photos or articles or whatever, and displaying them. And so because consumers were removing photos and displaying them, Comics World merely followed up what the industry was doing to create a trend, or to follow the trend, of creating centerfolds, making it easier so you don't have to cut into pages and maybe cut out part of the article and you lose part of what's in the stories. You just want to display the picture because this wrestler is your favorite guy. And so you had a centerfold. Great. Perfect. It's an extension of what you were already doing. It's an extension of the newsworthy story. And you just followed the trends of what the magazine industry in general was doing. So what was the final ruling? The court said, sorry, Titan, sorry, WWF, your motion for summary judgment is dismissed. Comics World, congratulations. Your motion for summary judgment is granted, and Titan's complaint is dismissed with prejudice. So what does it mean when it's with prejudice? It means Titan can't bring that again. They could appeal it, and they may have. I'm pretty confident they did not. But you can appeal it and say that this court screwed up and it should be overturned. But the difference between prejudice and without prejudice is, if it's without prejudice, you could bring the case again. Here, the court said, look, there's no real facts in dispute. There's no real question here. It's Titan, you're whining and complaining about something, and you're wrong. And, these folks are allowed to print these poster magazines so long as they've got these news stories in there about your wrestlers. And so Comics World went off and continued to print for as long as they printed. Not sure exactly how long that is. I'm pretty confident they're not still in business today, but I could be wrong. So what do you think? Did the court get it right? Were they right in allowing poster magazines? Because the publisher paid lip service to news and articles. It sure seems so to me. But the door would be open for claims for any magazines that were strictly photos or strictly posters and did not have news articles. So, I think it's a pretty easy line and easy thing for publishers to have gotten around and even to continue to get around. But what do you think? Do you think that these magazines should have been allowed to do this? Do you think they should be allowed to have these photographs and reproduce them and sell them on newsstands without compensating the wrestlers or the entity? The same would go for any online publications. It doesn't have to be printed on paper. Think you got it right? I sure do, but I'd love to have your thoughts. So let me know. You can reach out to me with questions or comments or give me your thoughts. It's at Gimmick Attorney on Twitter. Same thing, at Gimmick Attorney on Instagram. You can always find my professional bio. It's at www.gimmickattorney.com, or of course at the Shoemaker Law Firm. So that's it. This is Mike Dawkins. I'm signing off from another episode of Wrestling with the Law right here on Ad Free Shows. Thanks for listening.